Never put these 7 things in your will. Hi, I'm Pam Moss-Garrett from LawMother, an estate planning and money protection lawyer who helps parents create generational wealth. As a lawyer, I've seen good estate plans and bad estate plans. And in this video, I've compiled this list of 7 things to never put in your will so you avoid some of the most common mistakes. First up, funeral plans. Your will is not the place to outline your funeral or memorial service preferences. Why? Because a will is typically not consulted until after the funeral is done. So if you only include those wishes in your will, there's a really high chance they won't be known or followed until after the fact. For example, a friend of mine chose a burial for her father. A week later, she discovered in his will that he wanted to be cremated. So she was faced with a challenging situation. She wanted to follow her father's wishes, but she kind of had already gone down a different path. Instead of including your funeral plan in your will, consider discussing that with your loved ones in advance and giving your loved ones a separate document with your wishes. For example, you may want to specify whether you prefer to be buried or cremated, if you have a preferred location for your service, if there are religious or cultural traditions you want to be observed. It's also important to consider the financial aspect of your funeral arrangements. Funeral expenses can vary widely, depending on the type of service and additional features you choose. To ensure that your funeral plans are carried out without causing undue burden on your loved ones, you may want to consider setting aside separate funds for them or purchasing a prepaid funeral plan. By discussing your funeral plans with your family in advance and documenting your preferences separately from your will, you can ensure that your wishes will be known and respected, providing comfort and guidance to your loved ones in a difficult time. Next, organ donation wishes. Organ donation is a generous and life-saving act, but your will not be the most effective way to express your wishes. Why? Because organ donation typically occurs at death, and most times your will be consulted a week after you pass away. That's why it's important to register as an organ donor and discuss your decisions with your family ahead of time. Registering as an organ donor is easy in most states and can usually be done at your state's Department of Motor Vehicles. Once registered, it's important to discuss your decisions with your family so that they understand your wishes and can provide consent for the organ donation if necessary. Third, retirement accounts and life insurance beneficiaries. Retirement accounts and insurance policies often have designated beneficiaries who will receive the proceeds upon your passing. These beneficiary designations take precedence over what you write in your will. It's important to keep your beneficiary designations up to date to ensure that your assets are distributed according to your wishes. In addition to primary beneficiaries, you may want to designate contingent beneficiaries who will receive the proceeds if your primary beneficiaries are unable to do so. This provides an extra layer of protection and ensures that your wishes are followed. If you have complex estate planning goals or concerns about asset protection or tax planning, you may want to consider creating a trust to hold your retirement accounts and your insurance proceeds. A trust can provide flexibility, control, privacy, advanced distribution strategies, tax minimization, creditor protection, and it also avoids probate. Bottom line, by coordinating your beneficiary designation with your overall estate plan and keeping them up to date, you ensure that your assets are distributed according to your wishes and provide for your loved ones effectively. 4, life support decisions. Your wishes around life support should not be put in your will. Why? Because a will isn't looked at until after you pass away, which means that those wishes won't be followed. Instead, you should include these decisions and choices in an advanced healthcare directive, also known in some states as a living will. An advanced healthcare directive allows you to specify what type of medical treatment you do and do not want. When creating an advanced healthcare directive, you'll have the opportunity to appoint a healthcare proxy or agent who will advocate for your wishes and make your medical decisions on your behalf. It's critical to choose someone that you trust and that you have the opportunity to discuss your wishes with in advance. By creating advanced healthcare directives and discussing your wishes with your family and healthcare providers, you can ensure that your medical care aligns with your values and preferences, even if you're unable to advocate for yourself. Number 5, trust assets. Often people create a trust online, and in that trust they say, for example, that they want their stock accounts to go to their daughter. They put those stock accounts in the trust, and a few years go by and they forget they created a trust. So they go and draft a will and they say that those stock accounts go to someone else. If you have a trust and the assets are in the trust will govern, not the will. Next, assets in an LLC. If you own assets through an LLC, a will is not going to control their distribution. The operating agreement and legal structure of the LLC will determine how the assets will be transferred. So if you own business assets or rental properties in an LLC, you'll often want to set up a trust and assign those ownership interests to a trust so it avoids probate and those assets pass the way that you want. Limited liability companies are popular business structures that offer liability protection for business owners, and they provide flexibility and simplicity in their operation. If you own assets in an LLC, it's important to understand how these assets will transfer upon your death and whether your estate plan adequately addresses their disposition. Number 7, personal information. While your will may contain details about your assets and beneficiaries, it's best to avoid including sensitive information because a will becomes public when you die. So you don't want to include social security numbers, bank accounts, or passwords in your will. Another thing that you should avoid putting in your will is personal details that you do not want to become public. For example, you would never want to put in your will that the reason I gave my daughter this amount is because she sees me every Sunday and my son gets nothing because he has an addiction to drugs. You wouldn't want that information to become public record. Additionally, it's important to review and update your estate planning documents regularly to ensure that they reflect your current wishes and circumstances. Life events such as marriage, divorce, or birth necessitate changes in your plan. After watching this video, you may be wondering, should you set up a will or a trust? That's why your next step is to watch my video explaining the difference between a will and trust, linked here.